Citing a case for a proposition it does not support, or citing a case that has been overturned, is considered serious misconduct. If opposing counsel or the court, often via law clerks, discovers the misrepresentation, the attorney's credibility is undermined, and the court may view their entire argument with skepticism. In egregious cases involving made-up citations or deliberate lies about precedent, judges may impose sanctions or refer the attorney for professional discipline for violating duties of candor to the tribunal.
That is exactly what the state of Arizona did in two cases, the Phoenix Federal District Court and the Ninth Circuit Court of Appeals cases, addressing Hempfling v. CVDC holdings. Except, the misrepresentation was to cover up crimes committed by the prosecutors and the defense attorneys and the defendants and the assistant court clerk, which made the filings crimes as well. The issue of both federal cases, primarily, was the quest to receive final orders in Hempfling v. CVDC holdings in the Pinal County, Arizona Superior Court, as the court had issued only a temporary place holding order confirmed by the Superior Court elected clerk. No final order had ever been issued, since crimes were committed inside of that case involving obvious bribery of assistant court clerks to withhold defendant responses and force a default that would have been later found to not be accurate, since responses were submitted to the court but hidden by the clerks. The submission of a misleading reference and claim was itself a crime. Whenever a crime is committed inside a civil court case, prosecutors take jurisdiction in the case away from the court in order to accomplish the prosecution of the crime or crimes. In the issue of Hempfling v. CVDC holdings, the prosecutor threw that jurisdiction away and ignored it. The same prosecutor, Kent Volkmer, did it again, never pursuing the criminal proceedings, thereby protecting the guilty attorneys and clerks who set up and consummated the bribery acts, and the defendants, who obviously paid for it all. An obnoxious abuse of prosecutorial discretion. Another SCOTUS issue. The Superior Court knew of the bribery and refused to list the main law firm as representing anybody in the case. Kind of tells you where the crime originated from. The district and appeals courts knew of the bribery crimes as they were part of the complaint. The reason a final order had never issued in the Superior Court case. The state of Arizona, represented originally by Assistant State Attorney General Karen J. Hartman Tellez, and then by her replacement, Assistant State Attorney General Pamela Linens, both supervised by then Chief of Staff to Attorney General Mark Brnovich, since deceased, Michael Bailey, who left to become the federal prosecutor, the Assistant U.S. Attorney for the District of Arizona, where he could hide the case he had managed, offered a single defense in both courts. The Rooker-Feldman Doctrine. That doctrine is a major part of Henry Lee Kent Hempfling in the Supreme Court of the United States, as its use was not only a complete misrepresentation, but also abhorrently in bad faith. Henry Lee Kent Hempfling seeks clarification of the Rooker-Feldman Doctrine that it cannot be used in cases that do not address a final state court ruling. It was used in both of our federal Arizona-based cases as the reason to dismiss the complaints claiming the Superior Court had filed final orders, and we sought to have them overturned, when the very elected clerk of that court issued written confirmation that it had not. The district court case was responded to, with definitive proof from the Superior Court elected clerk and the clerk of the Arizona 2nd District Appeals Court, that claims put forth by the state of Arizona were not only false, but reprehensible as well. During that case, mail was stolen, attempting to stop our adhering to filing deadlines. The court was advised. A prosecutor took that case's jurisdiction and forgot about it. Then, the district court issued a placeholder. It didn't have jurisdiction to issue a real order, and we took it to the Ninth Circuit Court of Appeals, where more mail was stolen. That court issued another placeholder, and that is where the state case stopped. But it was not alone. Years before, we had been fighting corruption of the deepest degree with the NAACP and their control over executive branch agencies, FBI, EEOC, DOJ, USPS, DOJ Civil Rights Division, FCC, in destroying Lee Kent Hempfling's discrimination illegal firing case. Mail was stolen during that case as well. Prosecutors had refused to deal with crimes committed in that case, just like they did years later in the Arizona cases. So we took it all to the United States Supreme Court. At no time did we ever ask a federal court to review a judgment, placeholder, or final. We were seeking to receive an order from lower courts. All we wanted was the due process of a final order that had never been issued. On June 18, 2026, the United States Supreme Court ruled in TMV University of Maryland Medical System Corp., case number 25-197, that the Rooker-Feldman doctrine bars federal district courts from reviewing state court judgments, even when those judgments are not yet final and remain subject to appeal in state courts. That ruling does not apply to our cases as no review was ever sought. No attempt to overturn a judgment was ever made. No order was ever issued that an appeal could be taken on.
The Rooker-Feldman doctrine is a jurisdictional rule preventing lower federal courts from acting as appellate bodies for state court judgments, a principle established by the U.S. Supreme Court in Rooker v. Fidelity Trust Co., 1923, and District of Columbia Court of Appeals v. Feldman, 1983. The doctrine applies only when four specific conditions are met. The federal plaintiff lost in state court.
None of our cases had determined win or loss.
The plaintiff complains of injuries caused by the state court judgment.
No judgment was ever made. No claim was made for injuries.
The state court judgment was rendered before the federal proceedings commenced.
No judgment was ever issued.
The plaintiff invites the district court to review and reject that judgment.
We never asked for review.
In ExxonMobil Corp v. Saudi Basic Industries Corp., 2005, the Supreme Court clarified that the doctrine is statutory, based on 28 U.S.C. Section 1257, rather than constitutional, limiting its scope to prevent lower federal courts from serving as courts of appeals for state decisions. While the doctrine bars de facto appeals, it does not override standard preclusion doctrines or prevent federal courts from hearing independent claims that do not challenge the validity of the state court ruling.
We did not challenge any state court ruling. There had not been a ruling to challenge. Yet Arizona depended upon that defense, and when forced into the federal appeals court, they doubled down with the same argument and committed another egregious disaster of deceit. No court could issue final orders as the jurisdiction of the cases was taken away by prosecutors. Those prosecutors were running their own scam and hiding civil cases. Those issues are before the Supreme Court of the United States, and we eagerly await that ruling, which was filed on February 9, 2023, and has been displaying a placeholder itself ever since. SCOTUS stated on June 18, 2026.
The Rooker-Feldman doctrine bars federal district courts from exercising jurisdiction over cases brought by state court losers seeking review and rejection of state court judgments rendered before district court proceedings commenced. See ExxonMobil Corp v. Saudi Basic Industries Corp., 544 U.S. 280-284. This case asks whether the doctrine applies only to final judgments rendered by the highest court of a state in which a decision could be had, or whether it also bars suit when the state court judgment at issue remains subject to further review in state appellate proceedings.
The state of Arizona filed a flurry of obfuscation of the facts before both federal courts. No review of any state court order was requested, and no appeal was pending in a state court, as the placeholder issued by the Superior Court was not an order upon which an appeal could be taken. Arizona tried to insinuate the state appeals court had ruled against us. We submitted proof that an appeals court action was a special action, not an appeal, and it was never issued either. The Second District Appeals Clerk confirmed that in writing. The primary issue of Rooker-Feldman is review.
Federal district courts generally lack any power to review directly cases from state courts. Atlantic Coastline are Co. v. Locomotive Engineers, 398 U.S. 281-286. The Supreme Court is the only federal court with appellate jurisdiction to review state court judgments, and that jurisdiction extends only to final judgments or decrees rendered by the highest court of a state in which a decision could be had. 28 U.S.C. Section 1257. In Rooker v. Fidelity Trust Co., 263 U.S. 413, the court held that a federal district court lacked jurisdiction to declare a state court judgment null and void, because doing so would be an exercise of appellate jurisdiction, which only the Supreme Court possesses, and the jurisdiction possessed by the district courts is strictly original. In District of Columbia Court of Appeals v. Feldman, for 60 U.S. 462, the court held that a federal district court lacked jurisdiction to review a final judicial determination of the D.C. High Court because such review can be obtained only in the Supreme Court under Section 1257.
We never asked for review. We asked for our due process rights to receive a ruling. A constitutional right to seek redress of grievances is worthless if the receipt of a ruling is not likewise guaranteed. No attempt was ever made to seek appellate jurisdiction in either the district or the appeals courts. Pinal County prosecuting attorney Kent Volkmer took a lowly justice of the peace case, an illegal eviction based in extortion the police were aware of and were watching, using the court to complete that crime, while the plaintiff landlord wiretapped the court hearing without the court's knowledge and threw it away as well. That was pure retribution for his being caught, committing the crimes of his office in the Superior Court case. Corruption runs deep. SCOTUS has that too.